Interest in 25 minutes, meaning probably an hour. Concurrent estates. We are concerned with joint tenancy and tenancy in common. No tenancy by the entirety, although I do suggest that you understand that tenancy by the entirety is between husband and wife. There is right of survivorship. The only difference with tenancy by the entirety and joint tenancy is down to partition, whether one of the parties can partition by themselves in terms of creditors and things like that. So there's no need to get into it because it's not covered in our area. You will deal with that with family law. So we're going to concentrate on joint tenancy and tenancy in common. To be quick, the best way to approach this is to talk about joint tenancy, because once you know what joint tenancy is, then whatever is not a joint tenancy will be a what? Tenancy in common. So let's concentrate on joint tenancy. What's the signature? What's the key to a joint tenancy? Is what's called the right of survivorship. What that means is, with one of the joint tenants, co-owners, dies, the property then passes to the next automatically. Right? In some areas, like places that they follow the Napoleonic Code, like Puerto Rico, there is no such thing as joint tenancies. When you die, it passes on by estate, inheritance. Nobody gets the other side, and my sister and I were talking about that. They like it down there, and they would like to start joint tenancy. We are trying to get rid of it, and we want to be like them. That's the way life is. What are the requirements in order to have a joint tenancy? What are the requirements under the traditional common law? Still the majority rule. Still the majority rule is you have to have 4 unities. What was the point? The point was that if you did not have the 4 unities, it didn't matter what you called it. It was not a joint tenancy. Right? That's what I gave you on the test. I gave you a situation where it says that the traditional, let's not say the majority. The traditional, it's not the majority, the traditional common law requires that you have the 4 unities. If you have the 4 unities, automatically it was called a joint tenancy. No matter if you use the word joint, jointly, didn't matter. 4 unities, it was a joint tenancy. What are those 4 unities? Unity of time, unity of title, unity of interest, unity of possession. Unity of times. The interest of all the owners had to vest at the same time. So what does that mean? You have to have one instrument. You couldn't have one instrument granting one to one and another instrument now referring to the other one and saying, well, this instrument to be and creates joint tenancy. It had to be at the same time. Remember the rule. Still the majority rule, or the prevailing view, that you cannot grant a joint tenancy in yourself. There was a case in your book from California that said, it's the minority view, that in general what lawyers would do was create a straw man. They would give the property to somebody, right? That somebody would then give it back to both people, creating the 4 unities. California and about 4 or 5 other jurisdictions in the United States, they don't follow that anymore. They say it's useless. Lawyers find ways around it. It's a waste of money. It's a waste of time. Why do you have to have them turn it over and back? And in those jurisdictions, you don't have to have a straw man. The safe answer is you still cannot create a joint tenancy in yourself. That's the safe answer, the best answer. You cannot create a joint tenancy in yourself. Unity of titles. same interest, and at the same time. Unity of time, or granted, vested at the same time. Unity of title means that it came from the same document. Unity of one document at the same time. Not tomorrow or the day after. One grant to both of them at the same time. Unity of interest, half and half. If somebody got 1/3 and the other one got 2/3, you broke the unity of interest. It had to be equal. Otherwise, it's not a joint tenancy. And finally, unity of possession. Everybody has the right to possess the property in the same manner. No one is limited. If the moment you see somebody that has the right to possess it only 1/3 of the time, and the other one 2/3 of the time, you broke the unity of possession, and that in itself would not make it a joint tenancy anymore. That's the traditional common law. Somebody asked me something last night that I think that we need to understand. Common law is judge-made law. Under the common law, you have traditional, and you have majority, and you have minority. So a modern. So you can have the common law, you can have the prevailing view in the common law, or the minority view in the common law. Right? So common law doesn't mean that it's the modern law or the old law, and the new law is something else. So let's clarify that. Common law simply means judge-made law. Now, under the old common law or the new common law, there is some people that have a minority view on the common law, majority views under the common law. So a lot of people got confused about that. Let's clarify that. Somebody asked me last night, what do you mean majority? That's not the common law? Anything that's judge-made is common law. Outside of that, laws, rules, regulations are not common law. It's legislative law. So, and that prevails usually over common law. Right? So in jurisdictions where they pass a statute, the common law is over. The statute prevails. All right. Now we know how the modern law, under the modern law, the modern approach is you don't need the 4 unities. That's the modern approach. I think you should ask your professors if you're not in my section, but I really do think, and I haven't coordinated this with everybody else, and I will, you need clarification. It is my belief that the majority view still is the 4 unities. The modern law is the trend, the new approach, where it's going to, and it may well become the majority rule one day, but up to this moment, what I think is correct is that the 4 unities still remains the majority rule. So if you're not in my section, ask your professors, and I will ask them so we can have some sort of coordination, but I do believe that's the case. All right. What's the modern law? The only thing you need of the 4 unities is unity of interest. That's what you need under the modern law. However, because you only need one thing, it leaves a lot of confusion, right? So, to clarify the confusion, you have to be very clear that what you want is a joint tenancy. You can understand why, right? If you see a grant that says 1/3 to A, 2/3 to B, correct? And they all can possess the same, correct? Well, that looks like it's not a joint tenancy under the modern law, does it? Right? So how do we know? Because it breaks the unities, correct? But on the modern trend, we don't need the unities anymore. So how do we know that this is a joint tenancy, right? We would know under the traditional common law. We would know it's not a joint tenancy. Why? Because one of the 4 unities is broken, right? 1/3 and 2/3. So under the traditional common law, we would know. But under the modern law, we don't know. How do we know? Words. The words must be there. And what are the words that have to be there? Joint tenancy with right of survivorship. Now, in all jurisdictions, that will do. Joint tenancy with right of survivorship. That's the right way. That's the perfect way. In some jurisdictions, joint tenancy, jointly, might do. In a lot of jurisdictions, that won't do. That won't do. Right? So what you want to see is joint tenancy with right of survivorship. You want to see that in there. Some of you, in some of your commercial outlines, they tell you joint tenants. That's enough. Joint tenants. Jointly, your commercial outlines tell you is not. Joint tenants, it doesn't say right of survivorship. That may do it. But the best answer is joint tenancy with right of survivorship. All right. So that's how a joint tenancy is formed. Correct? The unities. How is it destroyed? That's the important part. It's not, once you have it, a lot of the questions and problems are about the destruction of the joint tenancy. Why is that important? Because of the right of survivorship. If you had a joint tenancy, right, and one of the parties died, the property goes to the other one. But if somewhere that joint tenancy was destroyed, right, now that property doesn't go to the other one. So it's important to understand when it's created, but also if it's destroyed. And we know that a conveyance by one of the parties destroys the joint tenancy. A conveyance. The trick here is, what if you have 4 people as joint tenants and only one of them conveys? Right? Well, that would destroy the joint tenancy only as to that one, but not the other 3. So A, B, C, and D are joint tenants with right of survivorship. 1/4 each. They all got it with the same instrument. On the same instrument at the same time, and the 4 of them have the right to possess the whole equally, right? I just gave you a grant that meets everything. That is a joint tenancy in modern, traditional, in every jurisdiction, right? You hear what I said? I just gave you a grant that is valid, that gives a joint tenancy in the old law, the new law, the modern law, the traditional, everything, right? And that's likely what you will find in the bar exam, but that's what I gave you. Why did I give you one that's good in everything? Because I gave you the 4 unities, plus I said joint tenants with right of survivorship, right? So I was very specific, correct? All have the same right to possess, the whole. Each one of them have the same amount, 1/4, correct? Now, what happens if A sells it? Sells the interest. Well, from now on, whoever A sold it to is not a joint tenant anymore, but the other 3 are. So the conveyance by A only destroys the joint tenancy that she had. So that's what I mean by destruction. Leases. Quickly, that's give or take 50-50 in the jurisdictions. The best answer is it doesn't. A lease does not destroy a joint tenancy. That's the best answer. That's the preferred answer. A partition action. A partition action will destroy the joint tenancy. Remember, because you were all confused in my test, right? In a joint tenancy, anybody can go and seek a partition without asking anybody else. You don't have to ask permission. The only time that you need to ask permission is in a tenancy by the entirety. You don't have to ask permission to convey your property if you're a joint tenant. You don't have to have permission to partition it. Right? If that's the point that, if there was a point of confusion last time on the test about joint tenancy, that was it. That you all thought that they had to go and ask permission from the other person. No, you don't. You and I are joint tenants, and I want to sell my interest. I don't need your permission. I don't even need to tell you. All I have to do is go and sell it. That's valid. If I want to lease the property, right, I don't have to tell you. I can lease it. However, how do we distribute the funds is a different issue, right? But I don't need to ask permission. If I want to partition, and we're going to talk a little bit about partition, I don't need to ask permission. I just go to court and say, hey, judge, I don't want this business of owning the hall between both of us. I want the east side. Partition it. Give me the east, give her the west. And after you partition, we don't have a joint tenancy anymore. Of course we don't. Once you partition, what happened? You destroy the joint tenancy, right? So now we're not concurrent owners at all. Listen to that. Blackacre, A and B joint tenants. A sells the west. No, A goes to court, asks for a partition. Court divides Blackacre, west to A, east to B, right? A and B are not concurrent owners anymore. Why are they not concurrent owners? They don't share anymore. A has the west, B has the east. They're each owners in fee simple of one half. They're not concurrent owners anymore. Why not? Listen to what I'm telling you. Partition does what? Destroy the joint tenancy. So how can you have a joint tenancy after it's destroyed? So what you have to keep in mind is, how is a joint tenancy created? Right? So the question, look, is this about creation? If it's not about, was a joint tenancy created? The next question is, was it destroyed? Right? And what destroys joint tenancies? Sales, conveyances, partition actions, right? Leases don't. The last thing is a mortgage. A mortgage. I go out and I mortgage my half, or I get a security interest in my interest. Not half of the property. You cannot do that because I don't own half of the property. That's the other confusion students get. You don't, when you get a mortgage, you're not getting a mortgage on the west side because you don't own the west side. You have interest. So the mortgage is on half an interest of the whole Blackacre. See? This is what concurrent ownership is. You have to visualize this because we tend to see this in halves. I got a mortgage for half of my interest. Well, that means a mortgage on the west side. So if they default on the west side. No, you only have west side and east side when you do what? Partition. Otherwise, what you're getting is a mortgage on half of the interest, not half of the land. You don't have ownership of the land. You have an interest that you share with another owner, right? That gives you the right to enjoy the whole, even though you only have half an interest. See? It's almost like stocks and bonds, right? You own an interest in a corporation, right? Now, you don't go and take over the corporation and own it. You don't have a little piece of the company, a little chunk. 100 people own a company. Well, you don't have 100th of the building that you go and chop off 100. What do you have? 100th of an interest in the company. That's what you have. Mortgages destroy joint tenancy only in a title theory jurisdiction. It doesn't destroy it in a lien theory jurisdiction. And the question has to tell you, if there's a question, you are in a title theory jurisdiction or you are on a lien theory jurisdiction. It would have to tell you that. So I wouldn't worry about memorizing the definition of title theory versus lien theory. All you need to know is that in a title theory jurisdiction, the mortgage destroys. In a lien theory jurisdiction, the mortgage doesn't. Right? That's all you need to know. So if the question says you are in a title theory jurisdiction, A and B are joint tenants. A goes out and gets a mortgage. When A dies, does B get the mortgage subject to the property? The answer is no. Right? Why? Because when she got the mortgage, what happens? It's destroyed, right? So whoever gets the side of A, the interest of A, is going to take that subject to the mortgage. B doesn't get it subject to the mortgage. You understand? Now, if you're in a title jurisdiction, that's different. In a lien jurisdiction. When A dies, since he didn't destroy the mortgage, guess what happened? Right? He got the whole thing. In that case, the majority rule is B takes free and clear. If it doesn't get destroyed, right, B takes free and clear. Right? This is why banks are so careful. This is banks when they have joint accounts, they make you sign all this stuff, saying that you need both signatures, right? So both of you have to agree to the loan. Both of you have to agree to the line of credit, because they know that if only one of you agrees to the line of credit and the other one doesn't, the bank might find themselves in a pickle if it's a joint tenancy and the other one dies. Right? So they make you both sign it, because you both then assume the problem. Of course, you have to be careful, because all this has been taken care of by legislative act. See? Remember, banks are big lobbyists, right? And they don't want problems. So they go to the legislature and they pass an act, like we saw in the notes in the book, where in Michigan, the legislature passed an act saying, even in joint tenancy, if one dies, the creditors have the right to take over the property. The problem in that case was that they never, pled the statute. You remember? The court said, have you pled the statute to the creditor? Have they pled the statute? That would be the case, but they didn't. They didn't. By the time they raised the statute, the case was already in the Court of Appeals. So you got to be careful about it. All right. That's pretty much how it's destroyed. Simple. So now we know how it's formed. We know how it's destroyed. Correct? So, a lot of times the issue is, it's easier, it's more clear to ask questions about destruction of the tenancy rather than about because of this stuff about modern law and traditional common law. It's always easier to just ask about the destruction of it. But when it gets more, what you have to really review is the rights and liability of the co-tenants when they are joint tenants and tenants in common. What are the rights and what are the liabilities? Yesterday we spent time trying to focus in landlord-tenant on what are the rights and duties of the landlord and what are the rights and duties of the tenant. Remember? Now we're talking about what are the rights and duties of the joint tenants and what are the liabilities of each one of them. This ought to be giving you a message as you study. We go back to the beginning, right? What gives you rights and duties? Possession, right? Now, you don't have possession, absolute possession. You own it, it's yours once you have possession. Depending on what type of possession, the courts will determine what can you do with it. You don't determine that. The law does. The law tells you how you can, how you deal with what you own. But you don't have rights and duties until what? Until you possess it, until you have it. I don't want to say own it, because there are times where you can have possession of something that you don't own, right? And yet have rights and duties, like with finders. So it's all about possession. So, when you have a fact pattern, right, and A and B owns the land, but A is B's lover, right, and B decides to rent the land, correct? If A gets any money, it's not by virtue of being B's lover. It's not, because they're not concurrent owners. They're lovers. Right? Now, if they now, as lovers, get the land as joint tenants, and they can, now A and B have the same rights. But until that happens, right, they don't have rights of co-owners until they either become tenants in common by virtue of a document or joint tenants. You understand what I'm trying to say? And I'm saying that those are little quirks that sometimes they're putting the questions to you in the bar exam, and you go all crazy, and you start finding the rights and liabilities, and you forget to find out that they were never joint tenants or tenants in common in the first place. You didn't read that. So, just a warning. What are their rights and duties? The right to possession. We know that, right? Right to possession. A, counterintuitive. Counterintuitive. This is all counterintuitive. It goes, you have to be a lawyer to understand this stuff. This is why, if you came to see Mayor Hawaii yesterday, he told you this, Lawyers are clever. Lawyers are clever. They go to law school and they intuitively learn these things, and people don't understand this. Mr. Goodrich, intuitively the other day, was confused about, well, not confused, but it didn't make sense to him intuitively. How can it be that somebody, gives title to two people, and then somebody loses the title even though after they got it? There's things that intuitively doesn't make sense, that somebody can move into your land, right, that you bought, and they can sit there and just cultivate the land for 20 years, and they take it from you. I mean, normally what you think is, American way, I bought the land, I can let it sit there if I want to, it's mine. Right? Who the hell are you to tell me that I have to cultivate it? I'm an old American hot-blooded person. It's mine. And I can do whatever the hell I want with it. So intuitively it doesn't make sense. The same thing here. Hey, I have an interest, but I can possess the whole. I can go anywhere in that land and enjoy it. I can hunt anywhere in that land. I can build the house anywhere in that land. I can swim anywhere in any of the lakes. I can use the whole. I have the right to possess the whole, even though I only have an interest. That's one of the rights. Right to possession. Right to convey. Right? You have the right to convey your interest. Tenants in common and tenants by entirety have the right to convey. You have the right to go and ask for a partition. Now, what's a partition? Simple, right? You don't want half an interest. You want half of the land, right? You don't want the right to possess the whole thing. Hey, give me my half. All this business about I can possess the whole, because remember, you can possess the whole as long as you don't interfere with the rights of the other party to possess their interest. You follow me? So, you say, I'm tired of having to go to the lake and be afraid that my partner wants to come in to use the lake the same day. I have a girlfriend, and I want to be there the whole month. I don't want to interfere. I'm in my honeymoon. I don't want my partner coming in and using the same house. I want to be alone. Right? I don't want to share. I want half. So you go and ask for partition. And there are two kinds of partitions. Voluntary and judicial. Voluntary and judicial. Voluntary simply means, hey, buddy, come here. You know what? Let's quit this. You take the west, I take the east. Do we agree? Sure. We go to court. We fill out the deeds. We made a deed granting, as joint owners. We now grant, we divide the land, and we grant A the west and E the west. We go and record that deed in court. Record it. Right? Hey, because if we don't record it, the other party goes out and sells it again, and now we have to worry about subsequent purchaser, right? So we partition it, we record it, and now I get to use my half, and you have no right to come in there. That's the right to partition. Here is what you need to understand about partitions. Right? The first thing the code would try to do is try to divide the land in an equitable manner, because in real life, we don't have the east is as nice as the west. usually what you have is, of course, one side wants the better half. And the other one says, wait a second, I want that half. So we have a problem, right? So what the court does is, it says, okay, let's equitably divide this, and if the left is the better side, we make the one that gets the left pay some money to the one that's losing out to balance it out. Right? That's equity. So everybody comes out winning. I got the worst piece of land, but I also have $300,000 in my pocket. Right? Now, that's la-la land. A lot of times what you have is ownership between 7 people, 8 people, 100 persons. What you have is like the case we saw with the lady with the garbage business, you know. What you have is a situation where interests are different and it's impossible to equitably divide it. In that case, as last resort, the court will sell the land by judicial sale and divide the proceeds. Judicial sale is last resort. That's the last thing. So if in the question you can see that it's possible to divide it without selling it, that's the best answer. However, if it's impossible because there's too many parties, you can't determine the value of the property, all those things, then you sell it. Right to lease, license, and grant an easement. Both a joint tenant and a tenant in common may lease the interest in the property. They may lease the interest in the property. The person that leases the property, his possession or her possession is not exclusive. Again, when you lease, what are you leasing? The same interest that the person that your lessor gave you. So you cannot be given exclusive rights. Now we know now from easements and covenants what exclusive means, right? You can have an exclusive right and a lease. It is possible to have exclusive right if everybody agrees, right? A and B agree. A is going to lease property to X, and we want to give her the exclusive right to the piece of property they're going to use. We can both agree. In that case, that's okay, if all the parties agree. Otherwise, you cannot give exclusive rights. One co-tenant cannot grant an easement in the property which will be against the other one without their consent. Makes sense now, doesn't it? I couldn't have told you this when we did concurrent ownership, but I can tell you that right now. What happens if I give an easement, a right of way to the property, and I may have a joint tenant? I'm giving somebody the permanent right to use that property, right? Now that may interfere with the rights of my co-tenant, because now we have a road in the middle of the property. So that means that my co-tenant can never use that road. They can use it, but that road is going to be there, right? So I cannot grant an easement without asking permission from my co-tenant. Rent. If you are a co-tenant and you live in the property, you don't have to pay rent. However, if you do rent and you have a right to lease, correct? If you do lease the property, you have the duty to account to your co-tenants for the profits made. Account. Duty to account. Who fixes the property? Well, contributions from the other tenants will be required for necessary repairs. Contributions will be required from co-tenants for necessary repairs. However, you will be, as a co-tenant, you will be required to contribute only if what? you were asked. If you weren't asked, you don't have to contribute. I said a couple of things here. I said necessary repairs. All right? Necessary repairs. Any other repairs that are not necessary, the co-tenants do not have to contribute to them. Okay? Taxes, where one tenant pays more than the share of the taxes, right? The other co-tenants are liable for that. Share of taxes. And, of course, both co-tenants are not permitted to commit waste. Now, yesterday we talked about waste, right? And, ladies and gentlemen, that's pretty much the current ownership. What did we do? We talked about how it's formed, right? We talked about how it's destroyed, and we talked about what the rights and duties are. Now, I went quickly through it. There are little details that I didn't get into it. I just wanted to point to you, so when you're studying, deep into it. I didn't give you all the, for example, I forgot to tell you that the exception to the co-tenant not paying rent is what? An ouster. And we know that an ouster has to be physical or by judicial decree. And we also know that when one tenant is ousted and they go to court and they get an action of ejectment against the other co-tenant, right? They're not kicking the other co-tenant out. All they're getting is forcing the other co-tenant to let them in. So when we hear action of ejectment, in this case, it's not the same thing as an action of ejectment in adverse possession. The co-tenant can never kick the other one out. All you can do is tell the court, tell him to let me use my property. Right? So in that case, the other tenant, if you oust, now you pay rent. Right? So I just wanted to put the framework in there. I don't want to spend 2 hours on this because, as you see from the disclosure statement, right, it's only a few questions. So move on and study the rest and the details. Yes?
When one tenant pays for property taxes, mortgage, insurance, can that tenant require an accounting from the other tenants?
You can ask for the interest on the mortgage. You can ask for it. The mortgage principal and the taxes, you are entitled to contribution. The mortgage principal, interest, and taxes. All right? All right. Everybody clear about all this? All right. Let's take 2 minutes.